Hi, my name is Caitlin Bonato, and today's case is O'Bannon versus the NCAA. Today, we will preview the facts of the case, the ruling, and what happened after. I came across this case while doing my homework and looking through many cases of agency law. This case really stood out to me because it talks about compensation for collegiate athletes, which is a big talk in sports right now and very relevant in the sports world. And it also stood out because the case was brought against EA Sports, which is a video game company. And video games are bought across the world by several millions of people every year. And I think it's unfair that these athletes that are being used in these games are not receiving any compensation. This case was brought to light in 2008 when the plaintiff, Ed O'Bannon, filed to sue the defendant, NCAA, EA Sports, and the CLC, which is the Collegiate Licensing Company. It was held in a bench trial in the district court, and O'Bannon was a former UCLA Bruin, and he claimed that EA Sports uses NIL, which stands for name, image, and likeness, while creating a video game for NCAA men's basketball. He later stated that he didn't even know that EA had used his NIL, and also that he had received no compensation for the trade of his image for using it in their video game. This brought up a lot of arguing between the NCAA and the courts, and the NCAA argued that they're trying to preserve amateurism, which is just simply stating that these college athletes are all amateurs and at this point in their career do not need to receive compensation in trade for their NIL. After the bench trial went through in the district courts, this court simply stated that the NCAA rules were unlawful towards the athletes. But even though they stated this, the NCAA still came out on top of the case. But this would only be a minor victory for them pending later cases. In conclusion, the bench trial pushed the NCAA to reward their athletes in some type of way, and this actually led to the NCAA allowing member schools to give out scholarships, which can be up to full tuition scholarships, and also additional payment to the athlete, which can go up to $5,000 a year. But this $5,000 a year would be put away into a trust, which the athlete will later receive once they leave college. Years later, after the case, O'Bannon still speaks out today about the Fair Pay to Play Act. This act is being talked about in California right now and has one more signature to go through in order to be signed into the law. Once it's signed into the law, it'll become effective in 2023. And this is just saying that any collegiate athlete during their career in college is able to sign endorsement deals and sign contracts and later be compensated for letting companies and endorsers using their name, image, and likeness. And the O'Bannon versus NCAA case is just a banner case for several student athletes to take a stand and talk about how they should be compensated for their actions, which would be letting companies use their name, image, and likeness. And there's all and it was just a banner case so that they could bring these facts up later, and eventually the Fair Pay to Play Act will be issued. I think that this case is very prevalent in today's sports world because I think that many student athletes are starting to realize that they go through a lot more than intended and face a lot more diversity while they play collegiate sports. And I think that they deserve to get a full compensation if their name, image, and likeness is used in any type of way outside of the NCAA. Thank you.